Well, greetings, everyone, and thank you for joining us today for the National Conference of State Legislatures 2016 Juvenile Justice Webinar. Again, my name is Sarah Brown. I'm a director in the Criminal Justice Program here at NCSL, and I'll be your moderator today. This webinar is a partnership project of NCSL's Criminal Justice Program with the John D. and Catherine T. MacArthur Foundation's Models for Change initiative. Our long-standing partnership with MacArthur is designed to highlight promising reforms and state approaches to inform state legislative efforts in juvenile justice. The webinar we are bringing you today, again, is Juvenile Life Without Parole, Miller v. Alabama, State Update. Back in 2012, the United States Supreme Court ruled that imposing mandatory life sentences without the possibility of parole on juvenile offenders violates the Eighth Amendment of the United States Constitution. The court's rationale extended from previous cases in 2005 and 2010, respectively, that struck down the death penalty and life without parole sentences for non-homicide crimes for juveniles. All of these cases cited the latest science on adolescent development research distinguishing juveniles from adult offenders. The Miller ruling in 2012, at the time, only applied to ongoing and future cases. But just a few months ago, in January of this year, the United States Supreme Court ruled in Montgomery versus Louisiana that the Miller decision does in fact apply retroactively to those individuals sentenced to juvenile life without parole prior to Miller. The new Montgomery ruling affects approximately 2,000 incarcerated individuals and now gives them the opportunity to either be resentenced or offered a parole hearing. So today our webinar will focus on how states are responding to these rulings and highlight actions that are applying the latest research and evidence to juvenile justice policies to hold kids accountable in more developmentally appropriate ways. We have brought together a panel of experts that will discuss the case, implications for state policy, and specific state actions. Our program will include first, an explanation and update on the cases from Marcia Levick, the Deputy Director and Chief Counsel of the Juvenile Law Center in Philadelphia. She's a national expert on juvenile law and will share with us her expertise on the cases, the research, and highlight remaining issues for states. Next, I will briefly highlight for you the state legislative actions in response to the Miller ruling. And finally, we're pleased to have with us Nevada's legislative staff, Patrick Guyman, who is the Principal Research Analyst at the Legislative Counsel Bureau for the Nevada Legislature. He will share the state's experience in passing its Miller compliance legislation in 2015. So today's webinar will include these presentations by these panelists, followed then by a question and answer period. To submit a question, which you can do at any time throughout, please use the chat feature on the left-hand corner of your screen. And in addition, this webinar in its entirety will be archived and posted on our Juvenile Justice webpage. So again, thank you so much for joining us. I'd like to now introduce our first presenter, Marcia Levick. In addition to her position at the Juvenile Law Center, Ms. Levick is an adjunct faculty member at Temple University Beasley School of Law. She was also counsel on record on the lead amicus brief filed on the Miller v. Alabama case and previous U.S. Supreme Court cases Graham v. Florida and Roper v. Simmons. We're so grateful to have you here with us, and thank you so much for leading off today's webinar. I will now turn it over to you, Ms. Levick.
Thank you, Sarah, and good afternoon to all. What I'm going to talk about is essentially to give you all the background on what the Supreme Court has been doing for the last 10 years, and then finish with a discussion about both the specific factors that the Supreme Court identified in Miller versus Alabama that sentencing courts must consider, and also some of the issues that have been raised as a consequence of the Montgomery versus Louisiana ruling, which made Miller retroactive. As Sarah mentioned, we have now had 4 cases out of the United States Supreme Court since 2005 in which the court has addressed extreme and harsh sentencing of children prosecuted and convicted in the adult criminal justice system. All of these cases have relied upon a foundation of science, both behavioral science, psychological research, as well as increasingly an awareness and consideration of neuroscience and the more nascent brain imaging and scans that I think many of us are very familiar with, that are also teaching us important scientific facts about the adolescent brain, and in fact its continuing development into the early 20s. In 2005, the Supreme Court decided Roper versus Simmons. This was the first of the court's new era of sentencing cases in which the court struck the death penalty for all juveniles who were convicted of homicides which they committed under the age of 18. In Roper, the court looked specifically at behavioral and developmental research that had been presented to the court and identified three specific factors that it relied upon in finding that children are different from adult offenders, and most specifically, different with respect to their culpability or blameworthiness for their criminal conduct. Those three characteristics were, number one, an immaturity of judgment and an impetuosity. Number two, a particular susceptibility to outside influences and negative peer pressures. And number three, of course, a unique capacity for change, rehabilitation, and reformation. The court spoke extensively in the Roper decision about the extent to which adolescence is a period of transition. It is a period during which the natural developmental phase that we go through as humans, there's a particular stretch of that, of course, from infancy through toddlerhood through the middle school years, and adolescence itself continues to be a period of change and growth, ultimately leading, of course, to maturity and adulthood. The court, in identifying those three factors, as I mentioned, relied upon these in its conclusion that kids are different from adults in constitutionally relevant ways that required the court to reach a different decision with respect to imposing the death penalty on children. And of course, all of these sentencing decisions are grounded upon the Eighth Amendment's ban on cruel and unusual punishment. 5 years later, the court was asked to address the constitutionality of life without parole sentences in non-homicide cases, so cases where while there may and certainly could have been severe injury or some injury, certainly these were cases where, again, these were non-homicide cases, no one was killed. And what the Supreme Court said in Graham was, again, looking at the behavioral science that it relied upon in Roper, and in Graham, beginning to look much more seriously at some of the new neuroscientific findings. The court said that, again, because of the reduced blameworthiness and culpability of juvenile offenders as compared to comparable adult offenders convicted of the same crimes, that it would be unconstitutional and cruel and unusual punishment to impose a sentence of life without parole on juveniles convicted of non-homicide offenders. The court drew a distinction, in fact, in Graham, between juveniles who did not intend to kill, did not in fact kill, and did not foresee that a killing or a murder could be a consequence of criminal conduct that they had participated in. The court was also particularly concerned in Graham with ensuring that juvenile offenders who are sent to prison for criminal conduct, that there be hope, that there be the opportunity for them to envision a time in the future when they could be released back into their communities, and that they have the opportunity to demonstrate their own growth and maturity to justify their ultimate release back into their communities. 2 years later, in Miller versus Alabama, the court was asked to now address mandatory life without parole sentences for juveniles who were convicted of homicide offenses. In Miller, the court, again, relied upon the specific three attributes of juvenile offenders that I've identified. Again, that would be immaturity and impetuosity, susceptibility to negative peer influences, and this unique capacity for change and rehabilitation. And here again found that a mandatory life without parole sentence also violated the Eighth Amendment's ban on cruel and unusual punishment even in a homicide case. And the court in Miller was concerned with a couple of very specific things. The court was concerned with not only this consideration about the potential for hope for a child or a youth sent to prison as an adult, but also very concerned that we not judge all children the same, and that in order to impose any kind of extreme sentence, such as even a discretionary life without parole sentence on a juvenile offender, that these individuals had to have each of their cases considered on their own merits. Much like in the death penalty case, youth had to have the opportunity to put forward mitigating evidence that would demonstrate that, again, they themselves were not the worst of the worst. One of the things that the Supreme Court has consistently identified in all of these cases is this view that sentences like first the death penalty, then life without parole in non-homicide cases, even mandatory life without parole, that all of these sentences in each of the circumstances presented could only be imposed on what we as a society would consider to be the worst of the worst offenders. And the court found these mitigating factors that you see on the screen now to be factors that, again, justified a view that kids are different, as I said, in constitutionally relevant ways that alter our thinking about how we sentence children. When the court, as Sarah explained, when the court decided the Miller decision, while I think many across the country assumed that Miller would in fact be retroactive, it turned out that there was a significant amount of disagreement among state courts about whether or not it was retroactive. And this meant that some of the aspects of the Miller decision were essentially left in a kind of limbo about how states should confront sentencing of juveniles who had been serving life without parole sentences, mandatory life without parole sentences, in many instances for decades. So what you see on your screen now are the Miller factors. And these are factors that were identified by Justice Kagan in her majority opinion, in which she said that courts at a minimum, in going forward and in choosing whether or not to impose a discretionary life without parole sentence on a juvenile, would have to consider, of course, the youth's age, would have to look at the youth's family and home environment. The court talked about the degree to which kids can't control the home environments in which they grow up in. These can often be abusive or disruptive or dysfunctional home environments, and that can have an effect on a child or youth's ability to make mature judgments and to make informed judgments about the kind of conduct and experiences that they end up engaging in. Of course, the court was concerned about the circumstances of the offense, and here the court is also looking at the degree of involvement. Was the child directly involved, for example, in the killing that occurred? Was the child a bystander? Was the child driving the getaway car? Did the child leave the scene of the crime before the murder was actually committed, but had participated in some underlying criminal conduct? The court felt that all of that should be looked at under this category of circumstances of offense. Possibility of rehabilitation, of course, is critical to the court's thinking about the circumstances under which such a sentence could be imposed. And the court was also concerned with the realization that many youth who are involved in the criminal justice system really lack the adult capacity or competency to both assist their counsel, but also to navigate the criminal justice system, to navigate a police interrogation, to protect their own rights during a police interrogation, to understand the kinds of issues that come up in considering whether or not to negotiate a plea agreement. So these were the core factors that the court identified in Miller. And in identifying these factors, what the court said in Miller is that we as a society should only be imposing even a discretionary life without parole sentence in only the rarest and most uncommon of circumstances. So in Miller, the court really laid the groundwork for thinking about essentially a fairly small sliver of the juvenile offender population who might get such a sentence in the future, or of course ultimately now who would be currently serving such a sentence, and whether or not that sentence could be reimposed. One sort of other note I would make about these three sentencing decisions is that each of them in their own way were categorical rulings. So the United States Supreme Court was looking at juvenile offenders as a particular class of offenders, and in identifying by its reliance on the scientific information that was presented to it, was really making categorical determinations about the characteristics and attributes of this juvenile offender population, and then ultimately barring specific kinds of sentences for that population. Following the court's decision in Miller in 2012, the Supreme Court was then, of course, ultimately asked to address and to resolve this question of the retroactivity of Miller. Between 2012 and 2016, there were, I believe, 18 state Supreme Courts that had considered the question of retroactivity. 12 state Supreme Courts had ruled that it was retroactive, but 6 had not, and so there was a substantial amount of confusion across the country as to whether or not states should now be imposing the new sentencing regime that the court identified and articulated in Miller, or whether it could, in fact, whether it was prohibited from certainly extending the benefits of the Miller ruling to the 2,000 or so individuals in roughly 28 jurisdictions who had been serving this sentence, again, many of them going back as far as the 1950s in this country. In 2016, in January, the Supreme Court addressed that issue, as Sarah said, in Montgomery versus Louisiana. And the court did, in fact, rule that the Miller decision was retroactive. The court found it retroactive because, again, the court was looking at the categorical nature of the Miller ruling, just as the Graham and Roper decisions were categorical. What the court said in Montgomery was that Miller prohibited a mandatory life without parole sentence for a very specific category of juvenile offenders, and that was that category of juvenile offenders whose crimes were really the product of transient immaturity. So the court was essentially saying that in Miller, it had prohibited the imposition of a life without parole sentence on those juveniles who essentially possessed the characteristics and attributes that it had identified in Roper and in Graham, and as well as in Miller. What Justice Kennedy did in his decision in Montgomery was he went not so much a step further, but he really underscored the limitations that the majority in Miller had articulated in limiting the circumstances under which a life without parole sentence could in fact be imposed on juveniles, even as a discretionary sentence. What Justice Kennedy talked about in Montgomery was he specifically wrote that only those juveniles whose crimes, for example, reflected permanent incorrigibility or irredeemable corruption, very high bars, only those juveniles could in fact be eligible to receive a sentence of life without parole, and as I said, even in a discretionary fashion. So we are now going forward as we think about the implementation of Miller now across the country, both prospectively and retroactively. States, of course, are now confronting the challenge about what that implementation means. Justice Kennedy, in the Montgomery decision, gave states a choice. He did not say that the implications of Miller required that every state provide a resentencing hearing for all of the juvenile offenders in their jurisdictions who had been previously sentenced to a mandatory life without parole sentence. Justice Kennedy allowed for the possibility that states could bypass a resentencing hearing and make these individuals eligible for parole and allow the parole process to determine that essential question that the court had first articulated in Graham, and that is giving juveniles a meaningful opportunity for release, giving juveniles an opportunity to demonstrate growth and maturity so that they could, in fact, return to their communities. The last slide that you now see on your screen is just to let you all know that there is a resource available. This had initially been produced for the MacArthur Models for Change Initiative. And the title of that publication, which is in front of you, The Supreme Court and the Transformation of Juvenile Sentencing. I recommend this publication to you, and there's a link there so you can see where you can in fact retrieve it. The publication goes through essentially what I have just done, but in much greater detail and in much greater depth. And that is to set up the framework and the foundational cases that led to the court's ultimate decision in Miller and now in Montgomery. There is also very helpful information in the publication provided by Dr. Tom Grisso and Dr. Larry Steinberg, really going through the specific kinds of scientific or expert witness factors that would be relevant in helping a sentencing court determine whether or not a particular juvenile crosses that threshold that the court identified in Miller and Montgomery, this idea of irreparable corruption or permanent incorrigibility. And so there is, I think, a terrific amount of guidance in this publication about how sentencing courts might proceed, and of course a lot of very helpful information for legislatures in thinking about their own task in implementing the Miller decision through legislative responses. And I think I will stop there. Turn it back to you, Sarah.
Great. Well, thank you so much, Ms. Levick, for your insightful presentation on these very complicated cases. As a quick reminder to our audience, you can use the chat feature on your screen to ask a question, and we'll get to all those following all of the presentations. So, as you have heard, over the past decade, significant Supreme Court rulings at the federal level have reshaped state juvenile justice policy across the nation as the High Court repeatedly prohibited the most serious punishments for juvenile offenders. This leads to our next portion of the webinar, where I will give a brief update on state legislative actions responding to Miller and other actions in states addressing juvenile sentencing and life without parole. During the time of the Miller ruling in 2012, 28 states and the federal government had mandatory juvenile life without parole sentencing laws that were in conflict with the Supreme Court ruling, as you can see highlighted here in yellow. The highest state mandatory juvenile life without parole populations were in Pennsylvania, Michigan, Louisiana, Florida, and California. So what's happened in the past 4 years? Well, this map depicts the legislative actions in green taken in the states since 2012 responding to Miller. Since the ruling, approximately 21 states have changed their laws for juvenile offenders convicted of homicide. 17 of these states were among the original states that needed, in fact, to comply with Miller. And interesting to note, 4 states on their own, of the 21 who took action over the past 4 years and revised their juvenile sentencing laws, were among those that were already in compliance with Miller at the time of the ruling. These states were California, West Virginia, Utah, and Montana. So what were some of the specifics of these laws? Well, what we've seen in the wake of Miller is that states actually took quite a varied approach. However, they all did give judges greater discretion in sentencing juveniles. In addition, 3 questions surfaced. First, when should a convicted juvenile become eligible for parole, meaning after how many years of serving time? Second, should discretionary life without parole still in fact even be a judicial option? And third, should the new legislation be retroactive, which we know now is required since the ruling in Montgomery in January, but still was an open question I wanted to point out from 2012 to 2015 that states looked at in crafting their new sentencing laws. So in response to the first question, how many years must a juvenile now serve before being eligible for parole? Again, the legislative responses were mixed as to the amount of years, ranging from as less as 15 all the way up to 40 years. And as you can see listed here on this slide, which I won't read, but you can kind of look over as I go along, 2 states required 40 years to be served before parole review, while 3 states set it at 35. We see 7 states required 25 to 30 years to be served. And the state of Nevada, which we'll hear in detail about from our next speaker, set the term of years between 15 and 20. In addition, as you can see here, 3 states set it at the lower end of 15 years. And finally, in 3 other states, An amount was not specified in the law and instead gave judges the discretion to set the term. So moving on to that second question I mentioned about whether or not life without parole should still be a sentencing option, again, we saw mixed state responses. Some states kept life without parole as a possible sentence for certain offenses, but then included language in the laws that the sentence can only be given after considering the mitigating factors of youth that you heard about from Ms. Levitt. But 17 states and the District of Columbia, shown here in blue, enacted laws to abolish or limit juvenile life without parole. Our next map depicts in purple the states that do not have any prisoners serving life without parole, either due to laws that prohibit the sentence or because there are not any juveniles serving the sentence at this time. And again, these, in the interest of time, I know I'm not pausing too long on each map, but these will all be on our webpage archived for you to look at a later time. Our final map in orange illustrates the most recent activity in 2016 that I want to highlight for you. 10 states so far have introduced legislation this year, with South Dakota's SB 140, striped in orange here on the map, being enacted into law just back in March of 2016, and Utah's HB 405, also striped and orange on the map, was actually just enacted into law a few weeks ago in early April. Both eliminate life sentences for defendants under the age of 18 at the time of the crime. And as you can see here, additionally, there are 8 other bills pending in the states addressing juvenile life without parole. In addition, not shown here, which was just brought to our attention after these maps were created this week, in Colorado, Senate Bill 181 has been fast-tracked and, in fact, passed the Senate Judiciary Committee just yesterday and is headed to the Senate floor. The bill eliminates juvenile life without parole as a sentencing option and could affect 48 juveniles in the state serving the sentence. And we will be sure to update and color Colorado in orange before we put the archive up for you on our webpage. Okay, I'd like to close this portion of the webinar with a mention of some additional NCSL resources available to you. Please know, too, that throughout the year, we, of course, will continue to track this important issue for states, produce publications with updates, and incorporate it into our juvenile justice meeting programming. But here's just a couple things I want to point out. As you can see here on the slide, I've listed a link to our Juvenile Justice Bill Tracking Database, where you can track and follow any juvenile justice bill, pending or enacted, including those addressing Miller and juvenile life without parole. Additionally, this summer, at our 2016 Annual Legislative Summit in Chicago, the week of August 8th, we will be convening a juvenile justice deep dive session there, which will touch on the issues covered today. And again, we are always available to you for ongoing technical assistance in your state as you work on these issues. So I'm going to go back to being a moderator now and introduce our final speaker as we turn our attention to the great state of Nevada. We are honored to have legislative staff Patrick Guinan with us today to talk about the state's compliance legislation enacted into law in 2015. Patrick has worked on Nevada's Legislative Counsel Bureau since 2002 and is currently a principal research analyst with the Research Division. For the last several years, he's also been assigned to the Senate Judiciary Committee and the Interim Committee on Child Welfare and Juvenile Justice. Mr. Guinan, we thank you for taking the time to be with us today and look forward to hearing about the work on juvenile life without parole in Nevada. I turn it over.
Go ahead. Thanks, Sarah. Thanks very much. Sorry to interrupt you. Hi, everyone. Like Sarah said, my name is Patrick Guinan. I work with the Nevada Legislative Counsel Bureau in our Research Division. I'd like to start just by thanking Sarah for having me join today on this topic. I think it's worthwhile and interesting, and I'm pleased to be able to present. And I'd like to thank Marcia as well for giving such a great overview to start with. And as you were told, I've been asked just to give you a sort of an in-depth view of how Nevada went about passing its juvenile life without parole revisions, which happened in our previous session in 2015. So I will get started just very quickly pointing out for some of you that may not know this, that Nevada's legislature only meets biennially, so 2015 and then 2017. And I think that's worth pointing out primarily because since Montgomery came out in 2016, if Nevada had waited to act on the retroactivity portion and not done something with it in 2015, we would have had to wait a much longer time, and I think that may have played into the decision to add the retroactivity into the bill that we passed. So with that in mind, I'll just start off by saying that the person who initially sponsored the bill is now the Speaker of our Assembly. His name is John Hamrick. He was not the Speaker of the Assembly when he submitted the bill draft for Assembly Bill 267, which was submitted just prior to our session beginning in February of 2015. Mr. Hamrick was made Speaker shortly after that. And I spoke with him yesterday about this just to refresh my memory a little bit. And as it turns out, Mr. Hamrick had known James Dold, who works with the Campaign for Fair Sentencing of Youth. He's their advocacy director, and those two gentlemen had known each other previously when Mr. Dold had worked with the Polaris Project on human trafficking. And as it turns out, Speaker Hamrick is also keenly interested in working on human trafficking issues and child welfare and juvenile justice issues. So they had a relationship prior to the session, and so Mr. Dole approached Speaker Hamrick about the Miller case and about wanting to do something in Nevada. Speaker Hamrick was more than happy to sponsor the bill, and so ultimately he became the primary sponsor on the bill, and it was sponsored, in the long run by several other legislators as well, and ended up passing out of the Assembly Committee, the Assembly Judiciary Committee, and then the Senate Judiciary Committee, as well as both houses unanimously. So by the time we got to the point where this was a public matter, it had incredible bipartisan support, and legislators were sort of chomping at the bit to jump on and be co-sponsors of the bill. And that doesn't necessarily happen very regularly. And in Nevada in 2015, both of our houses were under Republican control, as were all of our state constitutional offices. So the fact that we got that kind of agreement on a bill speaks very highly of the way it was handled. So I'll go into the bill specifically now, just run through the provisions of it for you. It was introduced containing quite a list of I guess you could call them Miller factors, but maybe even more than just Miller factors. It required a court to consider 16 factors if a person had been convicted for an adult offense committed when he or she was less than 18 years of age. And those factors included the ones that Marcia listed previously, as well as more specific remarks about a juvenile's ability to appreciate the risks of the actions they're undergoing, whether they exhibited impetuous behavior in the commission of the offense, the family and community environment to which the person had been exposed, all the kinds of things that you would think of as coming into play based on the Supreme Court's decision. And when the bill was initially heard in the Assembly, there was a great deal of testimony from folks for the Campaign for the Fair Sentencing of Youth project. Several, previous offenders who had been released came and spoke. There were folks from the various faith communities. There were experts on child development from the universities here in Nevada. There were defense folks. There were criminal experts. We had public defenders and district attorneys. So all of those folks came out and spoke in support of the bill. And the only concern with the bill came in the form of comments from the head of our Parole Commission, whose name is Connie Bisbee, and from the representative of the District Attorneys Association for the state of Nevada. And so the Parole Board's concern, and I think that Marcia sort of spoke to this a little bit, the Parole Board's concern was that they had a huge list of factors listed in the bill that they would have to take into consideration when they were looking at parole for someone. And the reality of the situation was that some of the factors that were listed were just not going to be available to the Parole Board based on the length of time that a given offender may have been incarcerated. The records may just not have been there, so that was an issue for them. And the district attorney Their folks were concerned more with just making sure that the bill wasn't written in such a way that victims' families or victims' advocates would have a problem with it, and that it would cause a stir. So ultimately, after the Assembly first heard the bill, the folks who wanted to amend it got together and did that and brought it back to the Assembly Committee for a second hearing with an amendment. And what the amendment essentially did was it removed those lists of factors from both what a court had to consider, and it removed the language on the parole board entirely in terms of what the board has to consider. And the reason I think that was okay to do here in Nevada is that, you know, our statutory scheme is our statutes are written fairly generally, and then the court will set its own rules, which are more specific. The parole board, through regs, will do its own regs to make sure that they're addressing the right issues. So the bill, in its final form, is a whopping 3 pages long, and I'll just read to you what the language was that replaced the long list of factors for a court. The bill reads, if a person is convicted as an adult for an offense that the person committed when he or she was less than 18 years of age, in addition to any other factor that the court's required to consider before imposing a sentence upon such a person, the court shall consider the differences between juvenile and adult offenders, including without limitation the diminished culpability of juveniles as compared to that of adults and the typical characteristics of youth. So you can see that rather than a list of specific factors, they've given the court some leeway to look at whatever it believes is appropriate, and, you know, based on what the Supreme Court has said, I think that our court folks here at least feel like they know exactly what they need to consider, and the parole board, I think, feels the same way. So, and then the rest of the bill, it's only 5 sections long, simply explains the portion that Sarah noted in her chat about the differences in length of time that someone must serve prior to being eligible for parole. So the 15-year mark in Nevada is for a non-homicide offense. The 20-year mark is for a homicide involving only 1 death. And then there's a third portion in the Nevada bill that just stipulates that the provisions of the 2 previous sections, the 15-year and the 20-year mark, do not apply to a prisoner serving a period of incarceration for being convicted of an offense or offenses that resulted in the death, excuse me, of 2 or more victims. So they leave those cases up to the discretion of the court. And that is the form that the bill finally came out in. And as I said, it passed every house and every committee unanimously. It was a good day for supporters of this legislation. I guess what I would follow up with now is just a couple of brief points. The parole board is now looking at how to implement this bill, and as Marcia mentioned earlier, you know, people are finding challenges. This bill took effect officially on October 1st of last year. And so they've been looking since it passed in May, I think May or April of 2015. The parole folks and the Department of Correction folks have been looking at how to implement it. And they're having some challenges, and they're probably going to come back to us in the upcoming session in 2017 with some changes, and that's why the implementation has been slow. For instance, I just spoke with our chairman of our parole board a couple of days ago, and just identifying those members of the correction system or those folks who are incarcerated who meet the criteria of the bill, that list of names was just finally produced, I think, within the last week or so, and it turns out that Nevada has just over 80 offenders who will be eligible to look at parole under this new bill. The problem, according to our parole commissioner, and I don't know if Marcia or Sarah want to speak to this maybe when I'm finished, the problem is that they have people who may have been incarcerated for 30 or 40 years and who, when they first went in, had no hope of ever coming out, and so they may not have done any educational programming, they may not have done any career programming, they may have essentially done nothing. And so now you've got these folks who may be eligible for parole and they need programming, and that programming hasn't been there previously. So that's one element that our corrections and parole folks are looking at. And then another element that I think is crucial and is part of the suggested changes that our parole folks are looking at is that the bill doesn't address any crime that may have been committed by an offender once they've already been incarcerated, whether they're a juvenile or not, and how to deal with those sentencing issues. And I'm going to try to read this little passage to you that came from our parole board. When you first hear it, it sounds a little bit like a high school algebra problem, so it may be hard to follow, but I'll get to the point quickly. This is an example of a scenario for eligibility for parole based on a current interpretation of this bill of ours, AB 267. A prisoner was sentenced to life without parole in 1979 for a murder committed at age 16. He escaped in 1982 at the age of 18 and was sentenced to a consecutive 5-year term. And in 1984, at the age of 20, he committed an assault in prison and was sentenced to an additional consecutive 6-year sentence. So there you have 11 years total of consecutive sentences added on top of the initial sentence. So here we are today, and now he served 37 years, but he became eligible for parole only on the murder conviction, and that's effective on October 1 of 2015. So if he's granted parole retroactively to the October 1, 2015 date, he then has to begin serving the 5-year consecutive term, and if he's granted parole on that, he has to begin serving the consecutive 6-year term. So the parole board's suggested change, which we're going to be looking at, I'm guessing, unless they come up with some other fix, but what we're going to be looking at in 2017 is that eligibility for parole would apply to all sentences the prisoner is serving or must still serve if the prisoner has been continuously incarcerated in any jurisdiction since prior to turning age 18. Eligibility for parole would be based upon the total time the prisoner has been incarcerated, including any time in another jurisdiction, if the prisoner has been under a sentence of imprisonment since prior to turning 18. So that's, I understand, a complex thing to listen to somebody read over a webinar, but I think it gives you a really good picture of what the issues are that our corrections and parole folks are looking at in the passage of this legislation, and how while we've made great strides, we're going to have to do some more work to get it right. And in addition, as I mentioned, we can't forget about the programming and educational elements that need to be designed and put in place for folks who've been incarcerated for quite some time. And that's all I have on the bill itself and its passage and potential future changes to the law based on that initial passage. The only other thing that I wanted to touch on very quickly was public perception in the state. I know people may be concerned with how their constituents or the public may view a bill like this coming down the pike. In Nevada, as you heard within the legislature, it was a very popular bill, and there was no testimony in opposition to the bill in either of the two committees in the Assembly or the Judiciary when the bill was heard. And we also track public comment on our website. You can go in and draw up any bill you want during the session and leave a comment or just say whether you like it or don't. And this bill didn't generate a whole lot of interest publicly. We had 22 comments for the bill and 5 against the bill, and 3 of the 5 against the bill just thought that it didn't go far enough and that people should be given even more of a chance. So that's a pretty good indication that there was really no opposition publicly or within the legislature. And I think part of the reason for that is that when this bill was first introduced in February when our legislative session started, there was immediately press at in both of the metropolitan areas of the state, both in Reno and in Las Vegas, that spoke to former offenders who were out. I think this is also something that and I don't know this for sure because this isn't part of my job, but I would imagine the campaign for fair sentencing had something to do with this, because we had some of the folks that came and testified to us also go on television and tell their stories, and they went and spoke in conjunction with a defense attorney in Nevada here who's works very hard with youth and defending youth. So there were television programs interviewing those folks, talking about the legislation. There were news articles that did the same thing, told the stories, and got the information out about who these people actually are and what they've been subjected to as children, and how their lives were impacted by that prior to committing a crime. So I think that by the time the legislature was acting on this, the public sense of the justness of it in combination with the fact that the United States Supreme Court had already said that these kinds of sentences were inappropriate, really sort of just snowballed, and the bill went through very quickly and without any problem. So I think now we're in great shape. When I spoke to Speaker Hambrick yesterday, I asked him what kind of reactions he'd had since the time of the passage of the bill, and he told me that he has received many letters from folks who are still incarcerated and want to know what they can do to maybe take advantage of this situation. He's received letters of support from the public for getting the legislation through in the first place, and he has not received one unfavorable letter, either from victims' rights advocates or a victim's family. So far, so good. And I think with that, I'll close my portion of the comments and ask if anybody has questions for any of the three of us. So I guess I'll turn it back over to you, Sarah. Thanks.
Great. Thank you so much, Mr. Gunn, for taking the time to share that with us and kind of walk us through your state's new law. It really is interesting to hear about implementation efforts. You know, states are at different stages, but to hear about your efforts and some of the challenges, some of those math problems with the eligibility for parole, really, and just all the different components of the justice system being a part of these efforts. So again, that was very interesting to hear, and we thank you for that. Again, this slide, as you see here, lists further resources for you for information on this. And I think now we've gotten a lot, but we're going to take some questions from the audience. And I will mention just up front here, if we do not get to your question, in the interest of time, because we are going to close at 1, that we will absolutely follow up and give you a proper response after the webinar itself. So rest assured that we'll get to all the questions. First, and I think seems to be kind of a theme here, on retroactivity, I think, because it's the most recent ruling in Montgomery. Maybe I'll throw this one to you, Marcia. And I know you spoke to this a bit, but states dealing with addressing this retroactivity ruling, are you specifically dealing directly with some of the juvenile life without parole kids in Pennsylvania, in your state, or others, and how that is going? And just if you could speak briefly kind of to that process that even Patrick just kind of mentioned, that the speaker was getting letters and all that. I think there's some interest out there on how states are grappling at this point in the wake of the ruling.
Sure. And with respect to Pennsylvania, which is where my office is situated, we are really just getting off the ground because we were one of those state Supreme Courts which had ruled that Miller was not retroactive. So we have the largest population across the country. We have about 500 juvenile lifers who are housed in prisons across the state. We have about 300 out of Philadelphia, so our numbers are really quite staggering as compared to the other jurisdictions that likewise house juveniles serving the sentence. You know, Pennsylvania and Philadelphia, the courts and the participants in the justice system are trying to work through the right way to implement Miller. My expectation is that Pennsylvania will likely pursue some type of resentencing hearing first before engaging the parole board in making perhaps an ultimate decision as to whether or not somebody is actually released from prison. I wanted to respond, if I may, to a question that Patrick brought up in his comments that he kind of threw out there about this parole process. And I think the parole process will be very challenging for a number of reasons. Certainly, the fact that there are many, literally hundreds of individuals across the country who have been in prison for decades. In many of those prison systems, they were indeed denied educational and programming opportunities because of the fact that they were considered to be a population that would never get released from prison. In Pennsylvania, I think that our own Commissioner of Corrections here in the state in 2012 actually began to open up programs without even knowing what our state Supreme Court would do. But we know this is a problem elsewhere in the country. And I think that also this challenge of figuring out issues of concurrent sentences, issues of periods of incarceration that an individual might be serving above and beyond a sentence that they received for a homicide crime are absolutely challenges that will have to be confronted either through parole policies, rules and regulations, or through the legislative process, trying to sort out how to adapt what is largely a system designed to think about individuals who are adults when they commit crimes and to measure their capacity for release or their eligibility for release against considerations that typically are relevant for an adult offender. Did they have employment before they went into prison? What were their community ties? Did they have a stable family relationship? These are issues that will likely not be relevant at all to a population of youth who have essentially grown up in a prison system. So many challenges ahead. I really think we're just at the beginning of sorting through what the national response will be to these really groundbreaking sentencing decisions.
Great. Thank you very much. Another question that we have here, a couple of them here, I think, again, a theme here. I can answer one portion of it, and then, Pat, there's a specific mention to Nevada. People are curious about these new laws and legislation addressing the issue and whether or not the language specifically mentioned in the compliance legislation, this is to comply with Miller. I would need to check on this, and I can certainly follow up, but in my last kind of analysis of this, it was several laws did, but not all in fact. So sometimes it's a little bit harder to track to see that they were in fact complying with it, and that's when you can go back and try to check and see of that slide of the 28 states that were not in compliance at the time of the Miller ruling. In fact, those states more often than not do mention that this is to comply. But again, I can post as part of the webinar archive a complete listing of that. And then Pat, for you, if you wanted to speak on Nevada, were they required to change their law per the Miller decision specifically?
Okay, this is Pat. Yeah, Nevada did not have mandatory life without the possibility of parole prior to Miller, but we did have life without the possibility of parole for a non-homicide offense. So I guess the answer is sort of. Nevada went in and got rid of it. And then I see there's a second question there too, which is, was there any discussion of race or racial disparities in sentencing in the context of passing this legislation? And the answer to that is yes. And in fact, it strikes me that virtually any time we have a bill up that has to do with juvenile justice and sentencing and corrections populations, racial disparities come up. And I've been staffing our Child Welfare and Juvenile Justice Committee during our interim periods for the last two interims, and that's been a subject of almost constant discussion. The interim prior to this one, our committee actually had a separate task force on juvenile justice that looked among a couple of other, as well as at a couple of other topics, but specifically at racial disparities in sentencing. And we now, the one I put the slide up previously with a couple of other entities to look at in Nevada, and I would just urge people, if you're interested in seeing a great model of juvenile justice reform, in 2011 our state Supreme Court created a commission on statewide juvenile justice reform, and I want to say there are about 20 members of it, and they come from everywhere: prosecutorial, defense, the court system, probation, public advocacy groups, and they meet year-round, about once a month, and they form subcommittees on various topics, and they've looked at racial disparities in sentencing quite a bit and will continue to do work on that. And in the last couple of sessions, that commission has been one of the prime sources for our legislature to get juvenile justice reform legislation introduced and passed, because when you get that sort of a mix of folks all in support of legislation, it has some punch. So that's why I listed our statewide Juvenile Justice Commission reform on the slide, and I guess that's about the best answer I can give. We look at racial disparities in sentencing and policing all the time.
Great. Thank you, Mr. Guinan. I think with that last question, we will wrap up. And again, we will be in touch with those of you that we didn't get to your questions. Just to kind of build on what Patrick just said, please do contact us at NCSL for additional questions for us or for any of these speakers, especially if there's interest in addressing racial and ethnic disparities in the justice system, as we have some resources and information and national data on that topic. So with that, I really want to just thank all of our distinguished panelists again for discussing these complex cases and providing updates and sharing specific state experiences. Ms. Levick and Mr. Guinan, we very much appreciate your time and presentations today. And thanks to you, everyone out there, for joining us on this really important and timely juvenile justice issue. We hope it has been helpful. Again, we'll have an archive of today's webinar with a couple of updates available soon on our website if you want to review any portion of it, or if any of your colleagues were unable to join us live today, it will be housed there from now and into the future for a while. So we do invite you from NCSL to really call on us with questions on this webinar and other juvenile justice issues at any time. Please just contact our office. I've listed on this last screen here my direct email and direct line. So thank you again. Have a great rest of the day and weekend. We appreciate your tuning in, and thank you again to our wonderful speakers. Take care, everybody.